Welcome to this unit on governance of data consent. By the end of this unit, you will be able to describe issues of data governance and consent for AI for health. Evolving approaches to consent. As discussed in Module 3, basic human rights safeguards, including data protection laws and data protection supervisory authorities, are important and relevant to issues of consent in terms of how an individual's health data is collected, used, and shared. As the types, quantity, and applications of health-related data have grown, various approaches have emerged to facilitate an individual's relation to their data. The main challenge is safeguarding an individual's privacy and autonomy by enabling them to control their data without limiting the purported benefits of their collection and use. There are mechanisms designed to provide individual control of data, including informed consent, duty of confidentiality, de-identification. However, these may not be sufficient as the quantity and uses of health data increase. A comprehensive approach to consent could be used, where consent is only given after the individual is informed of the potential consequences of providing it. For example, which data will be used, how it will be used, the consequences if consent is not given, who will use the data and for what purpose. Electronic informed consent is one way of improving individual control and choice. By using online forms to confirm consent for various uses of health data, electronic informed consent could provide individuals with a better understanding of how their data will be used, and more control over their data. Another approach is dynamic consent, which allows individuals to modify their consent periodically for uses that they wish to permit and those that they specifically exclude. A third approach is to seek broad consent from individuals to facilitate secondary use of health data for health research purposes, without undermining their rights to privacy and autonomy. This is where individuals provide consent for data sharing with named industry partners, prospective, explicit consent for future secondary use of the data for research, waived consent. Governments could choose to define when consent can be waived in the public interest. For example, in certain situations, governments could have a duty to share health data for the benefit of the wider public, such as to improve quality of life or health. In the UK, genomics is an example of where health data has been shared for public interest. The burden of demonstrating that a lack of consent is undermining a benefit should rest with the entity that seeks to avoid consent. It could imply that obtaining health data without the specific consent of the individual is justified if the benefit outweighs an interference with the right to privacy when the risk is low. A system in which benefits and risks are weighed could, however, lead to data sharing without consent. Medical benefits could be considered more important than a low risk of a serious interference with privacy from the use of the data. Another concern is that a government or a company may define public interest in a way that is not based on public health or patient need. Whether patients share the benefits may depend on the entity with which they are shared. Benefits may not be shared if the medical products or services are neither affordable nor available. Conscripting health data with the goal of contributing to the public good is questionable when the data is shared with a commercial entity. Use of data without consent. Data protection laws are intended to safeguard the privacy of an individual's data. However, concern has been raised over instances of data being shared with private companies without the consent of patients. In Japan, an approach to resolving such conflicts was the passing of the Jisedan Iryo Kiban Ho, next-generation medical infrastructure law, which permits hospitals and clinics to provide patient data to accredited private sector companies which are responsible for making the data anonymous and searchable. Before sharing data, hospitals and clinics must inform patients and give them the right to opt out. The accredited data companies anonymize and store the data, making it available to academic researchers, pharmaceutical companies, and government agencies for a fee. Accredited data companies are required to institute safeguards for cybersecurity, unauthorized use of data, and unauthorized disclosure by employees. In 2020, the EU proposed a means for using data without consent under the concept of data altruism. This would allow companies to collect personal and non-personal data on individuals for projects that are in the public interest. This approach seeks to limit the type of company that can collect data by specifying that it must be constituted to meet objectives of general interest, operate on a not-for-profit basis, and be independent of any for-profit entity. Ensure that any activities related to data altruism are undertaken through a legally independent structure separate from its other functions, and can voluntarily register as a data altruism organization in an EU member state. Data altruism could raise concerns. First, this form of data sharing could lead to exceptions or grey areas in which health data are used for commercial purposes for which individuals would not wish to provide consent. Secondly, such a regulation could be rewritten to redefine the entities allowed to collect data for altruistic purposes. Thirdly, even if the health data were initially used for a non-commercial objective, the product or service that emerges might be licensed to or acquired by a commercial entity rather than remaining in the public domain. You have now completed Unit 1 of Module 7, Elements of a Framework for Governance of AI for Health. In the next unit, we will explore issues of data protection for governance of data.